Hello, and welcome to today's Contoural webinar, Creating a Modern, Compliant, and Easier to Execute Records Retention Schedule. First, for some housekeeping items. Today's presentation will be recorded. This recording will be shared with you via email tomorrow. At the end of today's presentation, we'll show a list of upcoming complimentary webinars. If you or any colleagues are interested in joining future sessions, please visit us at contoural.com and select the Events tab to register. We'll also share white papers, blog posts, and articles we've recently published. We also invite you to complete our brief post-event survey. We value and appreciate your feedback. If you have any follow-up questions or comments, please feel free to reach out to us at info@contoural.com. And now, allow me to introduce today's speakers, Tom Mighell, COO of Contoural, and Mark Diamond, CEO and President of Contoural.
Thank you very much, Chloe. Today we're going to talk about a very interesting topic. We've been talking about records management and records retention policies and schedules actually for quite a number of years, but it seems like every year it gets a little bit more harder, more complicated. I mean, years ago we used to just talk about legal and regulatory record keeping requirements, and then the world of privacy came in, and now we're going to talk about this today. The world of AI is coming into this. And so this is actually getting more interesting. And to some extent, it's also a little trickier because not only I think are the requirements that we're facing more difficult, but it's more important than ever to be able to execute that. So we're going to be able to talk about that today. And I'm delighted to have Tom join us. Tom, welcome.
Hi, everybody. Good to see you all today.
Tom is Chief Operating Officer of Contoural. He spends the better part of his week working with a number of both large corporations, mid-sized enterprises, nonprofits, public sector, just all types of organizations working on that. And I'm Mark Diamond, CEO of Contoural. And just a reminder, we are going to talk about technology. If you're a frequent attendee of our webinars, you already know this. We do not sell any products at Contoural. We do not do any e-discovery. We do not store any documents. We don't even take referral fees on any of these. Hence, our discussion on products is not because we're trying to sell you something or get a referral fee on it. It's just because we either have a good or bad opinion on that. We see lots of technologies being implemented, and at a certain while, you get a pretty good feel of what works and what doesn't, but not motivated by any fees out there. So I'm going to sort of kick it off and talk a little bit about what we see out there in terms of old-fashioned records retention schedule. And I mentioned we've been doing this for a number of years. And it feels like we oftentimes see schedules that were literally written 15 or 20 years ago, or sometimes feel like they were written 20 or 15 years ago, even if they were written a couple of years ago. And the attributes of the schedule, they sort of stick out to us. These old-fashioned schedules, in our view, tend to be somewhat paper-centric. They recognize most records being paper records, and yeah, maybe they talk about emails or files a little bit, but they sort of assume that most information or most records are in paper, which quite frankly isn't true anymore. They tend to focus on what we call big R records. These are records, these are the legal and regulatory requirements for keeping information. And clearly, these are very important. We're not saying ignore them, but old-fashioned schedules tend to focus on that exclusively. I think there's an old-fashioned thinking process that a schedule can and should only contain legal and regulatory requirements. And as we'll talk about, we think that impedes organizations. They tend to be overly long and detailed. I mean, we see schedules with maybe the policies is dozens of pages, or more important, the number of records categories, hundreds of records categories, in some cases, thousands of records. They tend to be very long and very detailed. I actually think this habit was promulgated by law firms or consultants that build schedules because they told their clients saying, oh, if you build a really long schedule, it's going to be more compliant. And no, actually, we think the opposite. We think something overly long and detailed actually drives non-compliance, but we see it in a lot of old-fashioned schedules. And finally, it's a real lack of consensus with the business. We see schedules that are created, and if you go to the business units or employees and saying, by the way, do you know this is what you need to save or not save? And they're going, what? Well, first of all, they may not even know there's a schedule. And second of all, they may say, well, yeah, I'm familiar, but I've got other stuff I need to save above and beyond that. And they're going, well, I'm going to follow that, but I also have these other things. And so there's really not a consensus. And these issues very much come up when it comes to over retention and the desire to be able to delete this. And so if there's and excuse my biblical analogy, I'm coming down from the mountain holding my tablets of a records retention schedule saying, thou shalt do this. And that doesn't work very well. We really want to battle over retention, but we need to be much smarter about how we approach it. And so we are seeing organizations do the switch to a more modern schedule, and we're just going to kick off the conversation.
Wait. Hey, Mark, before you leave that slide, I want to bring up one more thing because I've started seeing it lately, and I think we need to talk about it. Overly long and detailed schedules are definitely hallmarks of old-fashioned record schedules, but I have lately found a lot of older schedules that are the exact opposite. They are too short and do not contain enough information. They will just say things like accounting records. They leave it up to you to decide what those accounting records are. They may not have all the records that are in them. These are schedules that are usually put together by law firms. Most of the ones that I've seen lately are put together by law firms. They don't reflect everything. They don't have all the information that users need to be able to understand what records are being kept. So I would say that's another hallmark of an old-fashioned schedule, is these really short schedules that are not easy to implement and are hard for users to understand.
Tom, are they like created from a boilerplate or something like that, do you think? Or
no, I think that somebody just had an exercise. What kind of records do we keep? Oh, we keep accounting records. Let's list that out. We keep HR personnel files. Let's list that out. We have contracts. Let's list that out. But they're not really listing the fact that within accounting, we're also keeping invoices and accounts payable records and other types of examples. They're not really they're only thinking about these high level categories. I think it's something that is taking a very short amount of time. It's a check the box activity for whoever is doing it, and it's not sufficient.
So let's talk about what makes a good and modern schedule. And Tom, I'm going to turn to you first. What about records across different media, or what does a modern schedule do?
Yeah, this should go without saying, but there are a couple of items on this slide that actually we still hear from companies that are a little confused about this. We want to make sure that a retention schedule identifies records regardless of media. A schedule is media agnostic. We recently reviewed a retention schedule that include a separate line item for email. We're going to keep email for this period of time. We had to explain that the format of the message, the format of the information isn't what this counts. It's the content that matters. So paper we're used to, electronic files we understand, application data getting a little bit out there, but yes, those contain records as well. Over to the far right side, social media, collaboration tools. There's a little shoe there because I like to always say I have no idea whether it's still happening today or not, but at one point in time, Nike used to consider exemplars of their shoes records. So the message there is, think broadly when you're thinking about what media might be a record. But I'll focus in on email real quick. A lot of people want to just put a line for email and say we're going to keep all email a certain period of time, which doesn't make sense because we all know that email will have information about contracts or HR records or an invoice it needs, and they all have different retention periods. So identify the content across all media, and then that will help drive your retention periods.
Tom, what do you say to organizations that say, well, we just declared that there's no records in email?
I mean, that's a beautiful sentiment, and it's a nice goal to have. I mean, when we talk to clients, we like to say email should be thought of as purely a communication tool, but the reality is that your employees are having business communications within email. So you can't just declare there's no records. You have to be able to say, all right, we recognize there are records. Let's figure out how to deal with them there. Not the subject of this particular webinar, but let's figure out where they should go or how we should manage them so that we're appropriately dealing with records. Because the truth is, we went through an exercise about a year or two ago with one company. They were interested to know in their schedule how much of the records in their schedule were contained in email. And we sent out surveys to the employees, and literally every single category in the schedule was reflected somewhere in an email.
And I should just add to that if you look at the regulators, the single largest regulatory fines for records management in the billions of dollars was a few years ago against a number of Wall Street firms for exactly that. They had messages that contain records that they said, oh, these don't count. And they said, yes, they do. And it was literally millions of dollars worth of fines out there. We've got a question. I've seen separating similar records, even though they have the same retention period. Is there merit to separating them, or is it better to merge? Assuming legal requirements are the same. And how do we, sort of figure out what are the right size buckets on this, Tom?
So I'm going to give the legal answer, which is it depends. Usually we like to try to combine them into as small categories as possible. We want and assuming the retention periods are the same, then that's actually an easier argument to combining. Part of a modern schedule is making sure that it's ready for implementation. And the more categories you have, the more, for example, if you're using Microsoft 365, the more retention labels you're going to have to create. So the idea is, let's make sure that we group similar records together with the same retention period. But if it turns out that there are records in that category that don't have the same retention period, we need to keep them differently. That's when you'd start breaking them out. But we try very hard, as long as the records are similar and the retention periods are the same, we try very hard to keep those together for simplicity purposes.
Now, the next slide, I'm going to talk about this a little bit. There are some vendors out there. There's one vendor that says we can build your records retention schedule in minutes. There are some, you can buy these off-the-shelf records programs, products or programs that say, we'll just, very easy and fast to create them. Here's the problem. They are pretty good about determining company or typical records. We can sit here today, we can tell you in minutes, we too can tell you in minutes, 70% of your common or typical records, finance, HR, administrative, or regulatory records. I mean, that's easy. However, that's only usually 70% of your records. 30% are company specific or departments, or organization specific, division specific, or firm specific, whatever you may be. Operations, processes, programs, IP, trade secrets, business value. And even among two companies in the same industry of similar sizes, whereas they're typical records are going to be very similar. The company-specific records may be very, very different. And we see a lot of schedules out there. Again, this is my pet peeve of just created with this sort of push-button approach. We're going to create your schedule with the product that miss 30% of the company, a good chunk of these specific records. And quite frankly, it's non-compliant. It puts your organization at risk, because when the courts and regulators come in, yeah, they may look at the common or typical records, but more often than not, they really want to know about the stuff on the right. So we think it's very important to be able to identify the company-specific records in addition to the common or typical records. And you got to dig in and find that stuff.
The other important thing to think about here is it even like Mark mentioned, even in the same industry, records might be different. It might be that the records are the same. You keep the same records as a peer in your industry, but you might call them something completely different. That's why some of the off-the-shelf schedules fail, because they tend to go with a standard terminology that your folks aren't used to seeing. And there's nothing worse than putting a schedule in front of your employees and they say, what are these? We don't recognize this. This isn't what we call it. You want to make sure that whatever the records are that you have, you're naming them the way that your employees expect to deal with them. And that's really, it's really in that operational area that we find that happening more often.
Now, we obviously have a number of legal and regulatory requirements. And I know, Tom, this is a bit of a pet peeve for you. It's important to be able to get those correct. And so we want to make sure we understand all of the legal and regulatory requirements. You both obviously, at the state level or the provincial level or the federal level, but also on a per country basis. But sometimes you see this done incorrectly.
There are a number of databases out there that contain all of the regulations and record keeping requirements. And I think that for the most part, all of these tools are fairly comprehensive in terms of catching all the laws. Where the problems are is in the quality control of the way that they've designed those citations. So what you're seeing here is an example from one of those databases, and it's on the left is what was listed, and it was listed as corporation, and that it was the what to keep was information relating to records of account books, which everybody has. All corporations have records of account books, but the retention period was very long. Thinking, my gosh, our account book records, we need to keep it for forever. When you go look at the law, you realize that they've specifically defined the word corporation to refer to only one corporation, the Tennessee Valley Authority, only one in the entire world to do that. And if you don't go and actually look at the law and figure that out, and there are a lot of other quality issues where it might not be quite so obvious that it's the Tennessee Valley Authority. It might apply to partnerships rather than corporations. It might apply to life insurance companies instead of healthcare insurance companies. You have to go and look at the regulations to make sure. These databases have good and comprehensive information in them, but the problem is there's lots of errors. So make sure that whatever you're doing, you're getting people to review and validate those regulatory requirements, because otherwise you might end up with a lot of an index of citations that either doesn't apply to you or doesn't apply in the way that you're expecting.
And so in this case, they looked at the word corporation and thought it applied to all corporations, when in reality it just applied to Tennessee Valley Authority.
There's one database that I found a while back that apparently they went through the laws of the state of Louisiana and they just did a search for the word maintain, because maintain means we're maintaining records. But they wound up getting a whole set of different. Different types of requirements around maintaining surplus for insurance. Completely not even a record keeping category. So it's these types of things we want to make sure you're paying attention to and you're validating to know what applies and what doesn't.
And so when you do a schedule, Tom, you like to go in and look at each. I mean, you validate them, each individual.
Correct. Absolutely. We go through each one. And we make sure that it applies.
Now, we think that doing good data collection is critical. I mean, there's one approach is to we'll survey people. We actually Tom, you like to go out and talk to people.
I do. I think there's value to talking to people. There are some companies would prefer that the schedule just get prepared. We think that is an issue mostly from the implementation and change management phase. Mark talked earlier about one of the problems with older schedules is a lack of consensus. That's a huge deal. Being able to talk to the business about what records they keep, how long they need to keep them, what's important to them, what information that they have that they're dealing with. But it's also a change management exercise with them. It's talking about the different retention periods, maybe negotiating with them on what the right periods are, educating them on why permanent may not be the right way to deal with something. So, understanding what the business needs gets you a schedule that is accurate and that is realistic and something you can implement, but it's also going to lead with buy-in down the road with the client, with the business units who say, yep, we were heard. These are the records we have. This makes sense. We've agreed to this. And that really helps with compliance with implementation when you're ready to start working on that.
No, Tom, some people say, listen, we got to get this done. I don't have time to be able to talk to everybody. I mean, it is more work. I mean, it is harder. How do you answer that?
I mean, it does take some more time to do. I mean, you have to meet with individuals and talk to them. We don't necessarily recommend meeting with everybody. What you see there is the minimal spanning tree. We want to look at, we find usually in most business functions, there's 2 or 3 people in each department that they have the best knowledge about all the records that get kept. And we find that interviews with just smaller groups is sufficient to get that information. Sometimes they bring a manager in who can then talk about, well, you know the records, but I know how long I want us to maintain those. That's usually a good combination because they can have a discussion back and forth about what they want to keep and how long they want to keep it. But it doesn't have to be a massive group. It's not a ton of people. We try very hard. We believe very strongly in the fact that this is nobody's day job to deal with it. So try to minimize their input, but also get enough input to where they're satisfied is the sweet spot.
And I guess the other comment we hear sometimes, I hear this, is that, hey, employees don't want to talk to people. They're fatigued. There's this sort of compliance fatigue out there, and they don't care about records. And so when you approach the employees, you don't say, hey, let's talk about records. They don't know what's a record or not, or maybe they have a limited idea of what's a record. Rather, we want to talk about what information do you have, what do you use. They're much more interested in that, which actually brings us to our next point, which is we have seen a significant shift in records retention schedules over the last 5-10 years. Traditionally, records retention schedules have only reflected legal and regulatory requirements. And the idea, if there's not a citation in there, it's not going in the schedule. We see many organizations now shifting their records retention schedule to include not only legal and regulatory requirements, but also business value. It is okay to include in a records retention schedule or declare something a record exclusively on business value, even if there is no legal and regulatory requirement associated with that. The idea is we want to identify high value information. We want to make sure that if it's going to help us run the business, if it's going to help us be more productive, it's going to help us be more collaborative. Let's make a point of saving it for the right period of time and making that available. That's really what we do. And I'm going to say something crazy. Organizations that include business value in their records retention schedule still retain less than those that don't. And I know that's counterintuitive. And notice how this also sort of shifts the role of records management altogether. It becomes just less of just a compliance function and more of, hey, this is not about compliance and risk mitigation, but this is also about employee productivity and collaboration. It's very important. Now, I've seen traditionalists. I had one client that had their previous law firm said, oh no, if you can't put business value in a records retention schedule, it needs to be in a separate policy. Having one policy for legal and regulatory requirements and a separate, schedule or policy for business value, I'm sorry, that's just, I think that not a good idea. I mean, you're having a conflict out there.
And let me extend that, Mark, because when you mentioned a law firm, I recently was involved with a law firm whose position was that the only records that really needed to have retention periods were the ones that had legal and regulatory requirements. If there was a rule around them, they needed to have a retention period, but the law firm considered that all the records with business value were reference. They were non-records, and so you can keep them forever. And I think that's a really risky issue for a number of reasons. You don't want to keep all that stuff forever for their litigation reasons, even though it doesn't have legal and regulatory requirements, doesn't mean it's not relevant in a lawsuit somewhere. So it's finding, again, the sweet spot, figuring out what the right period of time is, not keeping it all forever, but making sure it's included.
And part of our theme today is, the world is shifting. We're going from paper to electronic. We've gone to from paper to electronic. We have personal information. We want to use it for AI, and this may require us rethinking the records retention schedule if we really want it to be effective. And quite frankly, if we want to be more compliant. And we strongly believe that this approach is much more compliant than the more traditional approach. We've seen lots of compliance problems with the traditional approach out there. The other area that comes up here is negotiating with the business units. Now, let's be clear about this. Most organizations over-retain, especially electronic information. And a modern, compliant, easier to execute records retention schedule can be used to rein in this over-retention of information. It's actually a very good tool. It's part of that to keep the right amount of information for the right amount of time out there. Although sometimes there's this feeling, we get it, I talked to GC the general counsel recently, and he was saying, I really don't want to talk to the business units because they're going to want to keep everything forever. And that's going backwards. We want to save less. And I said, I hear you. But here's the crazy point. If we listen to the business unit, if we identify a reasonable amount of business value. You know, saving everything forever, no, that doesn't work very well. And sometimes if we have a little bit of compromise out there, here's an example. You know, somebody may say, hey, I need this marketing project plan for 10 years. And as an information governance professional, I'm going to roll my eyes saying, wow, that seems excessive. And before I say, no, 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 I may go, well, hold it. The marketing plan, that's like 0.1% of the overall information store. Maybe if I get a little bit more reasonable on saving a marketing plan, even though personally I think that's unreasonable, but this department really wants to do it. This person in this department may be much more likely than if I grant them the 10 years for the marketing project plan to delete the 60 or 70% of the other redundant, obsolete, trivial, all the junk, the email that says that they've been keeping for 9 years that says there's cake in the break room. And Tom, you focus on this. There's an element of reasonableness with this.
And that's part of the reason why the interviews are useful, is that we like to ask before we go into an interview, we like to ask, how far back do you need to go to access the information you need for your job? And most of the time, most of the clients that we work with, if I had to average it all out, probably say that they don't have to go back longer than 5 to 7 years to get information, sometimes 10 years, but it's never longer than 10 years. And we use that as part of the negotiation, is to say, you've already said you don't need to go back that far. Let's really talk about what's reasonable and figuring out how far have you ever had to go back. There's kind of that notion of, you never know when I might need this. And being able to talk to them and work them through kind of the anxiety about that is useful in getting them to negotiate on more reasonable retention periods.
There's an art to teasing out from people from employees that are used to saving everything forever, what's a reasonable retention period. And it can feel tricky, but actually there's an art to it, and it's actually very doable. We've seen that. Now, Tom, how about this? We've seen some organizations that, you know, obviously we have new privacy rules. These privacy rules limit how long you can save personal information. There's data minimization requirements. Some companies have a separate data retention policy in addition to the records retention schedule, but you don't like that.
Well, some have named their retention schedule their data retention policy, but a lot of what we've seen is that in groups that have privacy organizations, that have a privacy function that may be operating independently of a records function or an information governance function, or if you don't have one, privacy is usually going to take the lead. They may have developed their own retention policy that may not completely conflict with the record retention schedule, but it certainly is not in harmony with it. We get a lot of questions about how long does personal data need to be kept, and I think we're going to talk about that on the next slide. But the bottom line is, both of these policies, a records retention policy and a data retention policy, they serve the same goals. They serve the same purposes. How long are we going to keep certain types of information based on how we classify it, whether it's personal information, business information, things that have legal and regulatory requirements. But we believe that if you combine these requirements into one policy, into one schedule, you reduce confusion, you reduce the possibility of conflicting policies and different enforcement mechanisms by different parts of the organization. We think it's just more convenient to try to combine all this into a single entity.
Tom, what does that look like?
Well, I said before, we get a lot of questions. How long do I keep personal information? And in the United States, anyway, the answer is, well, that depends. The principle of data minimization is you shall not keep personal information longer than the business purpose, the legitimate business purpose for which it was collected in the first place. And that's the only rule. That's what California says. They don't give a retention period for personal information. There are very few laws in this country that have that. You go into the EU, we're starting to see more and more maximum retention requirements for you may only keep personal information a maximum of so long. We're starting to see that there, but not in the United States. And frankly, those data minimization principles exist worldwide. They're just because there might be some rules in the EU doesn't mean that the rule of legitimate business justification doesn't still exist. So what we do is we recommend that you look at all the categories in your retention schedule, identify those that have personal information and determine why the retention period you have is justified for whatever reason. And this is probably the easiest example, which is your business organization, your articles of incorporation, your board of director records, your bylaws, all types of things like that. There's tons of personal information in there. Your board of director information alone is a lot of information that a lot of privacy organizations want to regulate. The challenge is, at least in the United States, if not globally, is the rules of the states in which you are incorporated require that you maintain much of that information permanently. It is a permanent requirement to keep some personal information. So the idea, we call this privacy enabling your retention schedule. The idea is, let's figure out what personal information is in each category, and then let's determine what that legitimate business need is to keep it and to justify that retention period. What we've seen is that when you have that, it makes it a much more straightforward process. If a regulator comes to you and says, why aren't you deleting this information? You point to your schedule and say, we are really prevented from destroying it because of these reasons. Or if a data subject comes to you with a request for a deletion or correction or any of those things, you have that information to be able to give them the justification for why you may not be able to honor their request the way that they are expecting. We find that this is a way to help with privacy regulators down the road while staying in spirit with the privacy rules around data minimization.
So we have a question. Does that mean that privacy now owns the records retention schedule? By the way, these are all great questions. I'll do a first pass at this. Not necessarily. What we're seeing here is a bigger role for the records retention schedule because it's a fundamental component of an overall information governance program. In some cases, we're seeing privacy minimally weigh in, obviously, to privacy enable the records retention schedule. Sometimes we're seeing organizations combine their privacy and records management group. But even if you don't doing that, the ability for multiple groups to collaborate together, I think, is very important. And, that may sometimes, and some people may be concerned about turf wars on that, but in a lot of organizations, hey, if we can work together on this, this is going to be benefit because we can have the same thing that we can use for multiple purposes out there. And that tends to drive it. So it varies. We don't want to focus so much on who quote owns it, but rather how do we do this successfully and how do we engage more people to be able to share. The other thing I want to add to this is, if you've noticed, there's a theme here we're talking about. Remember, we talked about we want to make sure that we identify records across all media. That was very important. We want to identify not only typical records, but also company-specific records. We want to include not only legal and regulatory requirements, but business value. We're talking about here how we want to list what is personal information and within the policy and schedule synchronize the data minimization with the records keeping requirements out there. Let's get one policy and schedule that works, and having it all together makes it so much easier to execute. So much smarter for this versus, either not addressing these and sort of punting and down the road saying, oh, we'll figure out the business value later, or, we'll worry about this. If you're having problems on execution, part of our theme today, well, the problem actually may start with your records retention schedule, because if you can do this more modern, more compliant, more comprehensive, what I'm talking about, it's going to be much easier to be able to do this stuff. So that's, we're seeing a lot of organizations realize this. And again, hence we're seeing, we work with 30% of the Fortune 500. We see lots of organizations adopting this approach. All right. Now I'm going to jump into the world of AI, and specifically I'm going to talk about generative AI. And we can and have had entire webinars on this. A little bit of background. When we talk about using generative AI, there's all these different levels of using it. Maybe at a most simplest level, as some employees are using ChatGPT. Maybe at the next level, you're using assistive generative AI, maybe Copilot. Maybe at the level beyond that, you're using third-party applications that use generative AI. Maybe above that, we're using something called RAG, and I'll talk about that out there. But whether you're on the most basic level today or you're going towards some more advanced levels, we believe that modern records management will very much drive more compliant AI. And what am I talking about? So at its most basic level, if you're using generative AI, and I'm not talking about machine learning, I'm talking the more modern version of this, what you're really using is a large language model. And again, a large language model is just a fancy name for our AI engine. If you're using ChatGPT, it uses OpenAI's large language model. If you do a Google search, Gemini you'll have an AI summary on there. These are all basically large AI models, massive, that when they train or when they learn, they get lots of training web data from the web or other sources. And this is controversial. So there's litigation on there. The New York Times is suing OpenAI and Microsoft, saying you're taking out copyrighted stuff. And we're in the golden era of intellectual property law right now. Very unsettled questions on how much these large language models. But even if, putting the data provenance issues aside, or the legality of that, sometimes the sort of off-the-shelf data you get isn't good enough. And what do I mean? Go to ChatGPT, and I didn't check that this week, but that week, and you ask ChatGPT to create an image of a wristwatch at the time of 101. I mean, hey, I want a picture of 101. And ChatGPT, being the ever faithful intern, as we like to call it, comes back and says, okay, here's a wristwatch, and I set the time at 101. And you go, no. You set what was the date, should have been the date field, the little boxes at 101, but the time is at 156. And so you go back to ChatGPT and you say, that's wrong. Please fix it. And ChatGPT says, sorry about that. I'll go fix it. ChatGPT comes back and they give you another slightly different image and says, here it is, 101. And it doesn't have the date box, but the hands are still at 156. What's going on here? The training data that the large language models have used have scoured the web and other places for watch images. And the majority of the watch images they took to do their training on were usually from companies that sold watches. And if you're selling a watch, actually the best way to display a watch, if you're selling it and you want people to look at what an analog watch looks like, they're going to set the time at 156. So all of the data they've trained on, the vast majority has that. And so again, generative AI sometimes feels pretty smart, but sometimes it could be pretty dumb. This is a good example. It has no clue. It just does this. And so the data that we get off of the web, or the sort of out of the box training data, isn't sufficient. And so what organizations are increasingly doing, and you could argue this is somewhat of what Copilot can do, or if you have more advanced generative AI applications, they're using something called a technique called RAG, retrieval augmented generation. That's basically where, okay, I'm going to feed you data. I don't want you to go use the training data. I'm going to feed you data, and I want you to use it. And so that's called RAG. And by the way, RAG is going away to something called agentic RAG, where basically you don't have to feed it data. It's going to go look at all your data stores to find it itself. I mean, and we can debate of what point it becomes RAG or agentic RAG. But the idea is we have much higher quality data. I want you to make decisions using our companies or our firms or organizations' higher quality data, and just don't take any old data off the street. And this can work if you're doing engineering, if you're doing life sciences, if you're doing contracts. I don't want you to use any old contract. I'll give you sample contracts, and I want you to write a contract, but I want you to use our terms on contracts. That very successful. That works. And this is really, pretty soon we're going to look at how dumb we were, how trusting were you to just let any large language model take any old data. That wasn't very smart. We want to feed it good data. However, here's the catch. How do we make sure we feed it good quality data? If I'm giving you the contracts, how do I make sure you give us the most modern, the latest contracts with the right clauses? The contracts we used 4 years ago weren't any good. If we're using engineering data, how do we make sure it's good data? If we're using life sciences, how do we make sure that we're not feeding it, failed experiments, or at least not labeling it as failed? Failed experiments can still be useful data, failed clinical trials, other things like that, and giving it the most modern, valuable one. This is a data quality issue. And how do we find the good quality data to feed it? Records management to the rescue. This is really fundamentally a records management problem. We have a client who works for a very large global professional services and engineering firm. And she's an associate general counsel. And she says, you know what? I'm popular. Records management, I'm popular as a records management. What do you mean? And she says, our entire company wants to use generative AI, and we're getting on RAG, and they're all realizing they have a data quality issue, and they want to get good data. And now they're turning to records management to saying, can we delete this stuff? Can we do this? I have another client, that a global engineering firm, that she's also saying, hey, we have major initiatives to delete unstructured data, because not that we're worried about the risk, and although that can be an issue with it, but we just want to get the bad stuff out of there. So if we're using AI, we're doing this. And she said, this is a major initiative for our corporation. So when we talk about using AI, if you're not there yet, you will be soon, where we believe doing that. Now, what does this have to do with the records retention schedule? Remember, we talked about, we want good quality information in there. We don't want bad quality information. We want high value information, high business value information. Hey, we've got that covered. So we are seeing organizations modernize their records retention schedule, in large part to drive better use of AI. Now, not that we're giving up on the over retention risk or the compliance rules or the privacy. I'm not forgetting those, but hey, if that's what motivates the company to take a fresh look at it, get smarter execution, so be it. This all really comes along for the ride, and so we're seeing a lot of organizations move this way. All right. Another part of a modern schedule. Tom, do you like lots of country schedules, or do you like global schedules? I'm sure, obviously, teeing this up.
We don't really like country schedules because, one, they often conflict with each other. They're not always consistent, but it's an issue with implementation. It's an issue with consistency of treatment across the board. We've seen where some schedules have gotten completely out of hand, and the other schedules are catching up with it. That some schedules get very long, and others stay reasonably short. We find that the best approach is to go with a global schedule. We want to develop a baseline retention period for as many records as possible. We want to say that globally we are keeping our accounting records for 10 years, but recognize that there are places in the world, China being one of them, China's retention rules, crazy. They're going to want to keep those for 30 years. So let's identify local exceptions so that if we need to implement it slightly differently in China versus the rest of the world, we can do that, but it doesn't require us to create an entirely different implementation plan for every single country or region that we're in. I would also say a regional schedule, it follows the same issues. Is you're still basically setting up multiple different ways of implementation, and based on the schedules, you may have a lot of different approaches to that. You want to try to keep this as consistent as possible.
Now, Tom, is there like standard exceptions for everybody, or is this more schedule or company specific?
Well, this is more country specific. There are standard exceptions for certain types of records depending on where you're located and the types of operations that you have in that particular country. If you have employees in France, you're going to be keeping payroll records for 50 years. If you have life science records in the European Union, you're going to be keeping them for 25 years, clinical trial records for 25 years after marketing is finished. It really depends on where you're located, the industry that you're in, and what you do in that particular country to determine what those exceptions might be. And I'll just say real quick, a lot of times when you see, for example, we had one client who is in enough countries in the European Union that they decided to extend their retention period. They used to have a termination plus 7 years for personnel files, but there are enough termination plus 10 years in the European Union where they were located that they just decided, let's make that the global baseline. Let's keep it a little bit longer in the United States so that we're keeping it more consistently all over the world. And then you only have a few outliers. You have Poland and France as your 50-year, or Romania as your 50-year outliers, but you're keeping it the same amount of time in more countries.
So you sort of have to do the math, even though you have an idea, from client to client or company to company, this could vary.
You have to look at all the different countries that your company is in and make a decision on what that golden retention period is that makes the most sense for the most countries.
Yeah, I've seen some products that have out of the box, and I'm not a fan on that. Okay, Tom, I know this is a big driver for you. We see these schedules with acronyms or esoteric policy language, and the claim is, well, we need this because this is a legal document, and therefore it has to have either acronyms and especially esoteric policy language.
Well, and we talked about some of this a little bit earlier, but I would argue that those really short retention schedules that law firms come up with tend to run afoul of a lot of these things, because the bottom line is you want your schedule to be usable by the people who are using it. Ideally, if you're going to automate your schedule as much as possible, then the idea is to maybe not have them have to worry so much about what's in the schedule, but to the extent that you have paper records, to the extent that your people need to know how to use the schedule, making it as simple as possible and understandable as possible is really the goal. And one of those goals, I'm seeing it less, but I'm still seeing it, is the use of acronyms. I would say that acronym ACT, meaning active, is one of the most elegant and terrible acronyms that are out there, because it's very versatile. It can mean everything as long as this is active plus 7 years. But the schedules that include active have to include a table at the back to say active for contracts means until terminated. Active for employment files means until they leave the company. Instead of that, let's just say it. Let's just say that termination of the retention period for contracts is termination of contract plus 7 years, or a procedure. We're going to keep our procedures until they're superseded plus 7 years. Let's make it clear for the user so they understand what that event is before they need to delete that information. Likewise, we're seeing many more companies go to very short policies on record retention. We are going to keep records for their retention period. We are going to get rid of records once that retention period expires. Here is the definition of a retention period. It's not that long description that you're seeing there. And then legal holds. Legal holds will preempt the policy as necessary. We're seeing lots of 2- and 3-page policies these days where they used to be 10 and 12 pages. We want to try to avoid making long policies. Let's force them to look more at the schedule, tell them what they need to do, but then have them use the schedule and procedures to know how to do it. We talked about this part earlier. We want to make sure that the names in your schedule, the record types in your schedule, are things that you recognize, things that your individuals, your employees will say, oh, I know what that is. It might be that if you put in there and say reconciliation, your accounting people don't know what that means. That's a little crazy, but that's just an example. You want to make sure that if they're going to use it, they know what kinds of records belong there, which is why it's important to make it as custom to your company as possible to make them more comfortable. And then this is a hot take, an unpopular opinion. If there are records managers on the webinar, I apologize in advance, but we very much believe that it's okay to actually list non-records in the schedule. And hear me out for a second. I can hear people, I can see the pitchforks rising, say this is a records retention schedule. Why are you putting non-records in there? The reason is, forever, and part of the problem with older schedules and older policies is that the policies and schedules traditionally did a somewhat better job of saying, here's what you need to keep, but they did absolutely terrible at saying, here's what you can dispose of. Here's what's not a record and what you can dispose of. So it needs to go in the policy. You need to define non-records in the policy. But we believe that there should be a place in your schedule that you say, here's the stuff you don't need to keep. It's change management. It's reference for them to look at to say, oh, wait, so they can see, here are the things that I can get rid of. Far too many organizations have gone on with employees who have not gotten rid of non-records because they didn't think they had permission to do that. We think that by including it in the schedule, it helps a great deal with making them feel empowered to be able to take those actions on their own.
So I'm just going to highlight a risk, and again, you do enough of this and you see things pop up, and this one sort of bugs me. Now, there's one thought is the legal and regulatory requirements are changing all the time, and therefore I always need an up-to-date schedule. And so one approach is to have some vendor that keeps your schedule on a website, and as the legal and regulatory requirements change every week, reflect all the changes. And first of all, they don't really change that much, or when they do change, there's typically a long grace period. But that aside, we don't like this at all. We think that creates a this limits defensibility of your schedule because it creates a compliance gap. What do I mean? If you have a schedule that's sitting on somebody's website and they're always updating it, and you are not concurrently updating your training materials, your configuration on your systems, the privacy, all these different execution components of it, and you end up in a lawsuit, and your opponent, subpoenas your schedule and looks at your training materials, and that happens quite a bit. They may go, hey, your schedule said one thing, but your training material said something else. Why? Oh, no, well, that's just because the schedule updated more often and we didn't do the training materials. I'll repeat the question. The schedule said this is what you're going to do, but the training material said something different. What are you trying to hide? And now you're in explanation mode. And we've seen this. The idea that I can sit back and kick up my feet and automatically have my schedule updating sounds great, except it decreases the defensibility of your schedule and creates risk. When we update the schedule, we also want to concurrently update all the execution components, the training materials, configuration, the privacy, all the stuff that we talked about. Here's the new schedule. And by the way, we made all the changes to M365 or other things like that. So we're all in sync and there's no gaps between the two. That's a big driver on this. And so again, first, let's not create risk. Ironically, this sort of approach on the left is sold as a way to reduce risk. It actually increases risk out there. So we're really not fans of that, to do that. So part of what we're saying here is, if you get sort of an out-of-the-box schedule here, it's going to take more time. Out-of-the-box schedule you can create very quickly. One vendor says you can create it in minutes. Somebody else can say, hey, in a week you can have a schedule. You pay for that later on. If you have an out-of-the-box schedule, your schedule comes very quickly, but your execution time, which by the way is the vast bulk of the resources and energy you put in there, is much, much longer. Yes, creating a modern schedule takes more effort. I agree with that. I'm actually having there's a company we're actually having this exact conversation with the GC this week on. Admittedly, however, the modern schedule, much easier to execute, much easier to automate out there. And so, again, I know I'm a little counterintuitive. If we spend more time up front, it's going to help us. It's going to be less time. And sometimes it's easy to say, well, just hit the button, get this done. But we want to be smart about this. Again, we want something comprehensive, something we can actually execute. And when you do, life is much, much better. When you have your schedule, Tom, talk briefly about this. You don't have to buy a third-party product to display it.
Well, the bottom line is that we don't recommend uncontrolled copies of your retention schedule. We don't recommend publishing your schedule in PDF or Word or Excel or any of those things and making them available on an internet to where anybody can download them, and they then become quickly out of date if you update them and the individuals don't know that, and they're working off a different copy that may have very different retention requirements on them. We very much recommend that you centralize the publication of your schedule. It's great for the employees. They can look at it. They can't make changes to it, while you, if you're in charge of your schedule or whoever is in charge of maintaining the schedule, can maintain it very easily. One way to do that very easily using technology that you already have is Microsoft 365. we used to deliver schedules in Access database format, and obviously that was a terrible tool. But Microsoft Power Apps is what Microsoft is using now to develop very lightweight, no code type applications that look just like websites for your employees, and they can access the schedule very easily. It's fairly simple for your IT department to set up and maintain on the back end, and then your records team has complete access to it. So it's very easy to update and maintain. Again, this is something that it's not additional or new software. It's software you already have. It's part of your Microsoft 365 subscription. It's really about developing a configuration within that system that you can then use to publish your schedule.
And I'm just going to touch on briefly, because this is really a whole different webinar out there. But when you have your schedule, don't all of a sudden aggressively delete. Don't say, hey, we're going to be draconian, we're going to delete. Because when you delete stuff, you may freak out your employees. If I delete all emails after 3 months or 9 months, or I'm going to delete every file that nobody's touched in a year, you're going to drive a counter behavior that we call underground archiving, and people start hiding stuff. They'll put it in file storage or third-party applications, or even send stuff home, and that's that's just not good. We want to be careful on that. We do recommend, and again, this is a whole nother topic, which we have in the Contoural webinar series. We want to make it very simple to classify information. We want to do a drag and drop. You can teach Microsoft 365 all the rules, and you can follow what we call the 5-second rule, where we drag and drop files or emails, for example, into a folder, and the system automatically applies retention and sensitivity labels. People don't even need to know the rules. The system will manage it. The system will secure it. The system will delete it. We want to make this a highly automated process. And you can do this with, if you're an M365, you got the more basic E3 version. You don't need the more expensive version. Very easy to be able to do. I mean, not easy, but very very doable with the product you have. I mean, there's some legwork to set this up. I don't want to undermine that, but once it's set up, what I mean to say, very easy for employees to be able to use. And again, a whole different webinar, and we've talked about that. And the final thing we want to say is we're a big believer in not renting a schedule. We'd much prefer you to own your own schedule. It's something you can rent a schedule, which is faster, but it actually ends up being a lot more money. You still have to validate all the citations, and we talked about that, but it's not as bespoke. It's harder to automate. If you own your own schedule, easier to automate, easier to navigate, easier to update, a little more effort to develop up front, but much easier to adapt. So we're seeing a big switch from sort of renting a schedule to a lot more organizations saying we can own it. Matter of fact, we can store it in Microsoft 365. Better to do. And then just sort of finally ending up, how do we know this is okay? I mean, part of what kicked this off is because we had a very large lawsuit and the e-discovery costs were high, or we had a breach. And how do we make sure it's good enough? When a regulator comes in or a court comes in, they're going to look at your schedule, but that's only a small part. They're going to look at your schedule and say, what did you do? What's your privacy policy? What's your data governance policy? But then they're going to say, how did you implement it? What was the technology? What were your training programs? How did you actually do it? If you just have a schedule that sits there, you never implement it, that's going to create risk. And then the other question, which I think is the most important one they're going to ask, is how do you check it? How did you audit and surveil, report, or remediate, or update? Compliance and defensibility comes from what you're actually doing, not what you say you're going to do, not by having this super long, detailed 200-page schedule. That does not make you compliant. By having something reasonable, comprehensive, that we're automating, that we're following, and even if we follow problems, we're going to remediate it. That's what makes you compliant and defensible. And so we're really seeing a lot of organizations move the switch to this. Real briefly about us, as you can guess, Contoural, we create records retention schedules. We do really more information governance and records management than anybody else out there. We also have a number of other services. We're happy to tell that. The other thing we want to offer, we're doing a lot of these. We do virtual in-house information governance seminars. This is just for your company or your firm or your department, your organization. It's exclusive to you. It's us presenting best practices, some of the same things we talked about here, but a little bit more comprehensive. It runs an hour. Matter of fact, we can offer CLE credit for one state for where we do it. So not only the legal department, but we want all the stakeholders. Now let's get legal and compliance and risk and IT and information security and data governance all together. And we'll talk about what best practices are. We've seen this as a way to sort of get everybody on the same page. It's an hour, it's virtual, it's easy. We don't even charge for it. And it's not a vendor pitch for us. And we can give you references of lots of organizations we've done it through. Very popular, but it's a good way to get everybody. If you want to say, hey, I'd like to sort of get my team aligned. Hey, let's invite Contoural in. They'll do this hour. It's for free. It's CLE. It's nice. Consider it. Email us. We've got a webinar coming up next month. I'm using M365 for personal data inventory. We're doing a information governance 101, sort of a larger, what is information governance? As well as in May, we're going to have a very hot topic, real world data deletion strategy. We've talked about these, but these are, again, complimentary webinars all coming up to be able to do that. So happy to make that. And then we have lots of white papers, lots of featured articles, additional content that's available. Email us. I think we're out of time. We're happy to stay on for a few minutes if you want to ask some questions, but I want to be respectful for those that need to leave. I'm looking at, we've had a few questions come out there, but post your questions, and I'm sure we glossed over something or weren't clear enough. So ask your questions on that, and we're looking at that. And I'm waiting. We have a question here. Who usually runs the entire information governance program? I think what the question is asking, is this owned by records management, is owned by legal, is owned by IT? And good question. The larger answer to that for these type of initiatives, almost always it's a cross-functional steering committee. It's sort of getting all the stakeholders together. If one group owns it, the problem is that this covers a lot of area. There may be one group, legal is responsible for the policy, IT is responsible for the automation, maybe HR is responsible for training, but we tend to see much more often a cross-functional area. We've had some other questions. Okay, I think those are most of the questions. With that, all right, well, be respectful of your time. Take a look at our white papers, take a look at our virtual seminar, very popular, very good way to sort of get everybody together to kick off and modernize it. But in the meantime, thank you for attending, and we wish you success as you really think about taking a more modern, compliant, and easier to execute approach. Take care.
Thank you again to Tom and Mark for today's interactive and informative webinar, and thank you for joining us. We hope you enjoyed the webinar, and we look forward to seeing you on our next webinar on March 12th, using M365 to create a personal data inventory.